calls the matter of Smith versus Smith, case number 2015-6881 DM. If both parties could please state their name for the record, starting with the plaintiff, Beth Smith.
Beth Smith.
Glenn Smith, the defendant.
Good morning, everyone. Today's the date and time set for a hearing on a few matters. This matter is being done by remote technology due to the decisions of the Supreme Court and Chief Judge. The contents of this video may be official record of a proceeding of the state of Michigan's Ninth Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. Today's date and time set for an objection to referee's recommended order. My staff has handed me a stack of papers. I don't know if both parties have come to an agreement or not. I'll ask the plaintiff first. Ms. Smith, do you believe you've come to an agreement on all matters?
Yes.
Mr. Smith, do you believe you've come to agreement? Okay. Mr. Smith, do you believe you've come to an agreement?
Yes.
Okay, I do have a stipulation order regarding modification of child support. It was signed by both parties. There is an order regarding modification of child support. Both parties wish me to sign that, I'll do that. And then there are two child support orders with different start dates and effective dates. And overnights. Ms. Smith, have you seen these items and do you wish me to sign all of these?
Yes.
Do you believe it's in the best interest of the children and fair to both parties?
Yes.
Mr. Smith, have you seen all the documents I think you sent them to us, that you have sent?
Yes, I prepared them and sent them to Beth, and I agree with those being ordered or executed today. Did you get the deviation addendum as well?
I have two child support orders, and I'm sure my staff's telling me it's attached to one of them. So I can sign everything you've sent to me because both of you believe it's fair to both parties and in the best interest of the minor children. Any questions, Ms. Smith?
No.
I do have the deviation, and then it does not need to be signed by me, but it is attached. So any questions, Mr. Smith?
No.
Okay, well, I'm glad the parties came to an agreement and they believe this is what's best for them and most importantly, the children. So I will sign the orders. They will become effective today with signing them. And if there's nothing further, we will be adjourned. Anything further, Ms. Smith?
No.
Anything further, Mr. Smith?
I guess I do have one question. Is this, I guess we'll get a new calculation. There'll probably be a new calculation of arrearage and a new income withholding order.
Whatever the friend of the court does, they'll handle that.
Okay.
But hold on, my staff's saying, hold on. In your stipulation, you request on number 9, friend of the court shall recalculate support output relative to the time period and information set forth above, including recalculation of arrearage, issue a new income withholding order. That's up to the friend of the court. They'll get all this information, but it's up to them if they're going to decide to do all that.
Okay.
I would think all these orders I've signed has resolved it all. Are you saying you want to go back and recalculate?
Well, it just seems sort of intuitive to me that given the fact that some of the numbers may change, that there would, it may change the bottom line in terms of, the new numbers. But if they, we'll see what they come up with. That's fine. That was my only question.
All right, it'll be sent to FOC and then they'll see, but what may happen is the future. So we'll see what happens. This orders I've signed today is based on what has happened.
All right.
Okay? So I'll say that the FOC may recalculate the support obligation on number 9 in the order, and then we'll go forward from there. And if there are any changes on either side, either party can bring those up to the FOC, okay? All right. I'll sign all the orders as amended, and we will be adjourned if there are no more questions. Good luck, folks.